right. Happy Tuesday. I almost said Thursday because I'm used to doing forms on Thursday, but we're moving it to Tuesday. So happy Tuesday. We are going to dive in and cover the remainder of the forms updates. These updates are released every June and December. Last week, we covered the first half of the updates. Today, we'll try to get through the rest of those forms. Just keep in mind, I am going to only cover the forms that are pertinent to real estate sales transactions. So I'm not covering the commercial forms and I'm not covering the tenant or the lease forms. So just keep that in mind. Most of the more frequently used forms we covered last week. So look for that recording. And today we will dive into the additional updates. These should show up in your CAR forms library on the 18th of December is when they're slated to magically arrive in your library there. So if you go looking for these changes now, they probably have not been done. So the first form that we're going to cover is the seller property questionnaire. Keep in mind, just as a reminder, that we should not be doing the disclosures for our sellers, right? So we should provide them with the disclosure information advisory and then ask them to fill out these disclosures by themselves. That disclosure information advisory does a really good job explaining their obligation as far as disclosures go. So keep that in mind. If you do your disclosures through Glide, it actually pops up the information from the disclosure information advisory on the screen before they get to answer any questions, and they should be reading through that to make sure that it's well covered. If you help your clients fill this out and there's ever a lawsuit involved and they can come back and say, oh, well, I asked you what I was supposed to put there, or you told me to put this, now you've taken on that liability instead of them for that disclosure. So the seller property questionnaire just has a minor update here. They added on section 8D, they added any structure on the property is an auxiliary dwelling unit. So an ADU, yes or no. Has the ADU received a permit or other approval? Or are there separate utility meters? So those are the questions they'll have to answer with regards to an ADU. Again, if they answer no here, then they don't answer D1 and D2. So I think that was the only change made to the seller property questionnaire. Let me just scroll through. Oh, second one here, other on line 18, whether the property was originally constructed as a manufactured or mobile home. Okay, super important, yes or no. Then they re-lettered D. Some manufactured homes, just either they're actually on a permanent foundation off the chassis on the ground where you couldn't tell. My sister actually owned a property that was previously a manufactured home. Looking at it from the outside, everything, it looked like a regular home, but it actually was brought in sections, not site built on the lot. So just something to keep in mind there. So 18C is an additional question that gets answered. And then that is the end of the changes for that seller property questionnaire. We're going to move on over to our transfer disclosure statement. This is the other one. So that's the other seller disclosure that you should not be completing for your sellers. There was just a minor change here, and the only change that was made was they actually removed the seller initials off the bottom of page 2. Okay, so now it's because the seller signs on this page, they don't also have to initial. They sign here, buyer initials on this page. Both parties initial the page 1, seller and buyer initials on page 1. And then the agents sign, buyer and seller sign, agents actually sign twice on the TDS. Now, keep in mind here, I know I point this out a lot, but I'm going to point it out again. If this is your listing, the transfer disclosure statement is required in order to have a complete set of seller disclosures. And if we check the box here, okay, that says see attached agent visual inspection disclosure, which a lot of us check, this form is not complete until that AVID is completed. Okay, and ultimately you should not do the AVID until you're in contract on the property. Okay, see that conundrum there? So what I would do is I would mark the box here for agent notes the following items and just put in agent notes nothing at this time. that does not release you from your agent visual inspection disclosure. But by noting that, it then completes this form so that this form is now complete, because the AVID is not required as part of the seller disclosures. It's part of our duty as an agent, but it's not part of the actual seller disclosures. So if we check the box there, agent notes nothing at this time. The transfer disclosure statement is now considered complete as long as all the questions have been answered, the dates, the signatures are done. Super simple. And then you can do your AVID later on as soon as you are in contract. So just a little side note there. So that's the TDS and the SPQ, those updates. Let's move on to our next forms update. Commission agreement. There are two of these forms. One is the commission agreement, the CA. There's a second one for a single party compensation agreement. Let me see if I can find it. My Zoom toolbar is in the way, so it makes it difficult to find it. So let me see if I can find that single party compensation form. I think it's going to be this one. All right, single party compensation agreement. You're like, Amy, where would I use these? Okay, well, let's say that we send out golden letters, and we have somebody raise their hand and say, I'm ready to sell my property if you've got a buyer to buy it. I don't want to list it. I don't want to sign a listing agreement, but I will pay you compensation for selling my property to your buyers. So that might be where this compensation comes in, or maybe, who knows, but this is just for, like, we don't have a full listing agreement. This is just, hey, you're agreeing to pay me compensation in the case that I sell your property. So that would be the compensation agreement. The single party compensation agreement, that would be like the golden letter one. You bring the buyer, you've got the seller who says, yes, I will sell my house to your buyers, but I'm not listing it. They don't want to sign a full listing agreement. Fill in date prepared, principal, broker, the city, county. You're going to put in the full address there of the property. If the principal enters into an agreement with blank other party, that's where you put your buyer's names there, to sell or lease, right? So there's clarifying. So all the red words, those are the new ones, but that is the point of this form. Provided other party completes the transaction or is prevented from doing so by the principal, or in the case of the lease enters possession, right? B is other party includes any person or entity related to the other party or who in any manner acts on other party's behalf. So your buyer can't be like, just joking, my sister's going to buy it, so now there's no commission. No, it's still due the related to the other party. Including if the other party is a corporation, LLC, or partnership, any party or entity which the other party has a legal or beneficial interest, or which the legal or beneficial interest in other party. So those were the changes there. Principal warrants, principal has no obligation to pay compensation to any other broker regarding the purchase, sale, exchange, or lease of property. This agreement shall remain binding even if during the compensation period, principal enters into a listing agreement with any other broker to sell, lease, or lease the property, or a representation agreement to buy or lease the property, right? So both parties are agreeing that you're going to get compensated from this transaction, regardless of if they think it's going to fall through, they enter into a listing agreement with somebody else. We still have the benefits of the MLS and the impact of opting out of the MLS to warn them about selling their property off market. They updated this to read disclosure. If the property includes residential property, commercial property, or mobile home and is being sold or leased for a period exceeding 1 year, broker acting as agent for the principal shall give principal an agency disclosure form prior to presenting an offer to purchase or lease, right? There's no agency form attached to this one, so you would need to provide that. Representation, your choices here are broker will act as an agent for the principal exclusively in any resulting transaction, or the broker will act as dual agent representing both principal and other party in any resulting transaction. So are you representing just the seller, or both the seller or the buyer, or just the buyer? Okay, principal understands and agrees that a dual agent may not, without the express permission of the respective party, disclose to other party confidential information, including but not limited to facts relating to either the buyer or seller's financial position, motivations, bargaining position, or other personal information that may impact price, including the principal or other party's willingness to accept price less than the listing price or willingness to pay a price greater than the price offered. And except as set forth above, a dual agent is obligated to disclose no material facts affecting the value or desirability of the property to both parties. And so that was the changes made to number 2. They just added that verbiage in there just to clarify. 3, the option 3, so right, we have agent for the principal exclusively. 2 is dual agent, or 3 is broker will act for agent for other party exclusively in any resulting transaction, right? So that's, hey, we're just representing like the buyers, okay? The seller is choosing not to be represented. Principal agrees and understands that all acts of the broker, even those that assist the principal in performing or completing any of the principal's contractual or legal obligations, are intended for the benefit of the other party exclusively. Principal is advised to seek real estate, legal, tax, insurance, and other desired assistance from the appropriate professionals. This agreement does not require the broker to solicit offers on the property from other party, nor does it authorize broker to solicit offers from any other person or entity. D is the confirmation that they've added. Broker shall confirm the agency relationship described above or as modified in writing prior to concurrent with the seller's execution of a purchase agreement. E is potentially competing sellers and buyers. Principal understands that broker may have or obtain listings on other properties, and that potential buyers may consider make offers on or purchase through broker property the same as or similar to property. Principal consents to broker's representation of sellers and buyers and other properties before, during, and after the end of this agreement. Principal acknowledges receipt of the possible representation of more than one buyer or seller, disclosure, and consent. So there's clarifying that PRBS form there and then linking it to this form. Termination of agency relationship. Principal acknowledges and agrees that the representation duties of an agency relationship with broker terminate at the expiration of this agreement, or if it occurs first, the completion of any transaction specified in this agreement. Then we have the regular equal housing opportunity, applicable laws, attorney fees. Dispute resolution is what's covered next, which they've added. Mediation. Principal and broker agree to mediate any dispute or claim arising under this agreement before resorting to arbitration or court action. Mediation fees, if any, shall be divided equally among the parties involved. If for any dispute or claim for which the paragraph applies, any party, the non-mediating party, commences an action without first attempting to resolve the matter through mediation, or before commencement of an action refuses to mediate after the request has been made, then the non-mediating party is Then, if the non-mediating party is the losing party in any such action, the prevailing party in such action shall be entitled to recover attorney fees from the non-mediating parties, notwithstanding the terms in paragraph 5. Exclusions from this mediation agreement are specified in paragraph 6B. Right? We're agreeing to mediation, not necessarily arbitration. Additional mediation terms, the following matters are excluded from mediation. This is the same as what we see like in the purchase agreement, right? It's like judicial or non-judicial foreclosure, other action proceeding to enforce a deed, trust, mortgage, or installment land sale contract, right? Unlawful detainer action, the filing or enforcement of the mechanics lien, and any matter that is within the jurisdiction of probate, small claims, or bankruptcy court. The filing of a court action to enable the recording of a notice of pending action for the order of attachment, receivership, injunction, or other previous remedies shall not constitute a waiver or violation of the mediation provisions. Arbitration advisory, those are just, you record them against the title, stop the sale to anybody, so that you can proceed forward with this, and those don't violate the terms. Arbitration advisory, if seller and broker desire to resolve disputes arising between them through arbitration rather than court, they can document their agreement by attaching and signing the arbitration agreement card form 8RB. Of course, we have line 7. I feel like line 7 is always other terms and conditions. They manage to squeeze everything else in 1 to 6. Or see brokerage addendum if there's a specific addendum with other terms on it. Management approval. If an associate licensee in broker's office, salesperson, or broker associate enters into this agreement on broker's behalf, the broker and manager does not approve of its terms, broker manager has the right to cancel the agreement in writing within 5 days after its execution. This agreement shall be binding upon principal and principal's successors and assigns. 10 is the entire contract. And 11 is the legally authorized signer. Okay, it's just as allowing for entity principals. So this is the same thing that we see on the listing agreement and the purchase agreement they've added to this one, which allows for trusts, LLCs, corporations, probate, whatever that might be. Okay, principal signs here. Broker signs here. Okay. Keep in mind the agent can sign in lieu of the broker, and that broker does have 5 days to determine they don't like it. So that's the single party compensation form. Okay, that's one party is being paid from the transaction. The other form that they have is the compensation agreement, I believe is what it is, the CA, which is very similar. It's just identifying that you're going to get paid for this transaction. Okay, so this might be like, if you're not using the other form, you want to get compensated, we're not going to use a listing agreement. This would be the form that comes into play on that. So just kind of keep that in mind. Top is the same. Okay, it's talking about specific property, something to be negotiated between the seller, buyer, landlord, right? Let's see here. They've added principal's initials here to the first because it could be a buyer or seller. They're leaving that there. And then the only other thing is they lengthened the other terms and conditions line to like 4 lines instead of 1. And then they did do here to the entity seller information or entity principal information as well. So, and then did the full line here for that, as well as added the same verbiage that we saw on the last form that we see on the RPA and the listing agreement. So that would be the secondary commission form that you can use. I would think for the most part, you're probably going to use the single commission agreement, but it could be like maybe like I had a previous listing. Somebody contacted me, they've got a client that wants to buy it. Instead of signing a full listing agreement, we may just sign the commission agreement for that one sale specifically. So this would be where that would come into play. Or maybe your neighbor's like, hey, can you help me with this? Or, you know, who knows? So if you're representing the seller, not the buyer, we would use this commission agreement form. For representing both seller and buyer, single party, or there's no other agent involved in the transaction, only one agent, even if you're only getting paid from one side, we would use the single party compensation agreement. Okay, so that's the difference between those two forms. All right, moving right along, let's see what we've got next down here. Oh, let's go with the TOPA form. So our TOPA is our tenant occupied property addendum. So we utilize this form anytime that we have a property that is not occupied by the seller of records. So whether the tenant is paying rent or not, it could be a brother, sister, son of the seller that's occupying it. The seller doesn't occupy it, could be an actual tenant. We use the tenant occupied property addendum. We're going to check the box on the RPA that it's not seller occupied, and we're going to utilize this. Okay. Line number 3 was updated on this one. We did train on this one previously, so if you want to see the full training, you're welcome to find that. Line 3 was updated that the seller is able to remove existing tenants prior to close of escrow. Seller, as applicable, shall disclose to buyer when the property became vacant, whether the tenant vacated voluntarily, and if so, whether seller paid the tenant to leave, whether the seller filed a lawsuit or an unlawful detainer, and to attempt to evict the tenant, and if so, whether the lawsuit ended in a judgment. Okay, so their seller's required to do that if the tenant vacates before the close of escrow. So they've added that verbiage in. Okay, in addition, they added this or C down here. So A was tenants to remain in possession, B is property to be delivered vacant, and C is buyer is tenant in property, right? So even if your buyer is the tenant purchasing the property, we use the RPA, we use this form because the seller's not occupying the property. So now we've got a provision in here that explains that. C1 is buyer occupies properties or units. This TOPA form shall not apply for the property or units occupied by buyer except as outlined in paragraph 1C. C2 is security deposit. Seller shall transfer to buyer through escrow all unused tenants deposits, if any, and all prepaid but unearned rents, if any, prorated at close escrow. So the buyer is going to get their deposit and their prorated rent back. B or B is blank. You can fill something in there. And then C3 is for any units not occupied by buyer, all other terms of the TOPA shall apply. Okay, so you might be checking more than one box here. Okay, so it really should be like a or B or and C, because it could be both. Okay, so just kind of throwing that out there, but those are the changes that were made as for a tenant occupied property. Again, we would utilize this form even if the tenant occupied the property they were going to buy, if it was a single family residence. Security deposits number 7 was also added, an itemization of all lawful deductions made from tenant security deposits, if any, and a statement of the security deposit remaining after any lawful deductions have been made, CAR form sample letter, change of ownership, and security deposit allocation. If you want to know where to find that sample letter, just so you know, if you go into your CAR Forms library, you click on that, it says all forms, it will have sample letters in there. So if you ever want to access those, there's lots of cool letters in there. I encourage you to check that out. We did it at one point, but that was the change here, is just saying that, hey, security deposits, there's going to be an itemized list of any deductions made to those security deposits. And those were the changes to the TOPA form. Again, we use this anytime the seller does not occupy the property. The next form is, we've got a TOA, which is our text overflow addendum. The text overflow addendum gets automatically added to most of our forms. If you write more in a line than what can actually fit, it automatically flows to a text overflow addendum. But it's always been a text overflow addendum between the buyer and the seller. And now they've added a couple of forms. So this one, they added the addendum is given in connection as applicable, the property known as, that's where the property address goes, or the agreement, right, in which blank is referred to as the buyer and blank is referred to as the brokerage. Okay, so this is between the buyer and the brokerage. Okay, so they've added that TOPA form. They also added this one here, which is the TOPA. This one is the associate licensee manager team leader and the broker. Okay, so this one's between like agents in the office and the broker. They've added one which is between the buyer and the brokerage. That would be like it went over on the BRBC, the buyer representation and broker compensation form. It would flow over to this text overflow addendum. There's also one between the seller and the brokerage, and then there's one between the buyer and the seller. So they've just provided additional options for that text overflow addendum to make sure that it represents the correct parties. So those were the changes made to the TOA forms there. Let's head over to our next form, which is going to be the TEC. This is your tenant estoppel certificate. It's very common that when we have a grid format, which makes way more sense. It used to be just kind of line items, and now it's more of a grid type format. So rental terms, this references, same as purchase agreement, what paragraph is going to be talked about, the general terms, and then we're going to fill this out. So is the copy of the rental agreement or agreement attached here on two, either yes or no, right? Either one is attached or one isn't. The date of the rental agreement goes in there. The name of the current resident or rental property owner, authorized broker, agent, property manager, housing provider, formerly known as landlord. That's where that contact information goes. Name of any other adult tenants and occupants, and the age of all minors goes in here. Current monthly base rent amount. The current monthly base rent amount above is paid in full except, right? So we're assuming it's paid in full except you fill out that. Security deposit goes here, other deposits there. Maybe there was a pet deposit or a water-filled furniture deposit. Expiration of current rent term, number of location of parking spaces, number and location of storage spaces, any animals, service, emotional support, pets, if any described. Utilities and services, who pays? I like this. They've broken it down and made it super easy for us just to scroll through and see the information. Who pays for water, electricity, gas, waste disposal, sewage, garden landscaping? If applicable, what other utilities or services does tenant pay for? It might be like pool service, right? Or maybe pest service, right? And then you mark either the tenant or the housing provider pays for those. Appliances, super important again. Who owns the stove, the refrigerator, the washer, dryer, the microwave, or any other appliances would be line 24. That way we know what's going to vacate when the tenant vacates the property. So that's the new grid. Okay, additional representations. Tenant represents that the original agreement remains in full force and effect and constitutes the entire agreement between the tenant and the housing provider, except for the following modifications, amendments, addendums, assignments, extensions, or preferential rights or options to the purchase lease. There are no verbal or written agreements or understandings between the housing provider and the tenant. So they just updated this term to housing provider, just so you know, that was one of the things they changed in June, was updating some of those forms instead of landlord with housing provider, because it's less offensive. And so they're just updating that in most of these agreements. So you see anywhere there was like lease or housing provider. It's been updated with, lease or landlord has been updated with agreement and housing provider. Okay, so those are all the changes between 25, 26, 27. 29, again, just updated with the word agreement. And the person signing below represents that he, she, they, is, are duly, right? So it's he or she or they, is or are duly. So they just added some more pronouns and such there. And then the tenant signs and the housing provider signs. So that's the changes that were made to the tenant estoppel certificates. Again, if you've got a listing coming on the market that's tenant occupied, please have this filled out and ready to go before that property hits the market. Tenant signs this form, saying they agree to everything here. It'll make your transaction run much smoother. Okay, so tenant estoppel certificate. Moving right along, we have the REOL, which is the REO advisory for a listing. So this is if you have a property being sold by a lender after foreclosure. Okay, property foreclosed, lender selling it. Seller of the property is a lender who has acquired title of the property either by foreclosure or through deed given in lieu of foreclosure. Many obligations imposed on sellers, particularly of real property containing 1 to 4 dwelling units, may not be applicable to the sale of the property. However, even though the seller is exempt from some of the obligations, seller must still comply with many others. This advisory is intended to inform the buyer and seller of their rights and obligations, independent of those established by the contract between them. Seller must comply with the following, right? Here's the bank's obligations with regards to selling the property. They still have to disclose no material facts, hazard zones, smoke alarms, water heaters, right? It's not exempt from the fact that it has to have smoke alarms, that the water heater needs to be double strapped. However, the payment of those is not obligated to the seller. So you need to make sure you negotiate that in the contract. Lead-based paint, they still have to disclose any lead-based paint potential if the property was built before 1978. They still have to have the carbon monoxide devices in the property. They still have to disclose if they know of any non-water conserving plumbing fixtures. Okay. They are not exempt from tax withholding. They're not exempt from the Megan's Law database disclosure. Just so you know, that's usually done in the purchase agreement. It just identifies the website. And they're not exempt from the notice regarding radon or gas and hazardous liquid transmission pipelines. Again, that's usually in your NHD report. Seller may be exempt from the following: the disclosure statement. The seller does not have to complete and provide buyer with a real estate transfer disclosure statement, natural hazard disclosure statement. Those would be the CAR forms. Seller remains obligated to make the disclosures and comply with the items specified in paragraph 1. Other exemptions: the seller is exempt from providing buyer with Melrose district lien disclosure, improvement bond 1915 notice, the supplemental property tax notice, notice of private transfer fee. All those are in your NHD report. So as long as you get an NHD report, you still get those, even though the seller is not obligated to those. And the exempt seller disclosure. So the seller may be exempt from the exempt seller disclosure. Even exempt sellers have statutory and contractual obligations to make disclosures and may be required by the contract to use an exempt seller disclosure and is strongly encouraged to do so. Okay, but they may be exempt from that. Most people still fill them out, but banks are really funky, so you probably won't get one. Other obligations applicable to REO properties or bank-owned properties, that'd be real estate-owned properties. That's what REO stands for, real estate-owned properties. Selection of title and escrow. California Civil Code prohibits seller from requiring directly or indirectly a buyer to purchase title insurance or escrow services from a particular title insurer or escrow agent in connection with the sale of residential property improved with 4 or fewer dwellings. Buyer may agree to use the title or escrow provider recommended, right? Same idea as in our purchase agreement. So they just updated that verbiage on this form. Local law may impose obligations on the transfer of property, right? So the seller isn't obligated from that. So any of those requirements, whether it be a sewer lateral inspection, a pre-sale inspection, whatever that might be, depending on the local location of that property. Amendments to the contract. Seller prepared addendum amendments or counter offers or a seller prepared contract may conflict with, contradict, or be inconsistent with the terms in buyer's offer. Brokers cannot advise buyer or seller which specific terms in any offer may be affected, whether the terms of any such seller prepared documents are permissible under California law or in the it should say event of a discrepancy between the seller prepared documents and any other agreement between buyer and seller, which document or which terms may supersede the other. Buyers advised to seek legal counsel to discuss the applicability and interpretation of all seller prepared documents prior to signing any such documents. Almost always on a bank-owned property, they're going to have a bank-owned addendum that they're going to require you to sign as part of the acceptance of that contract. So that's outlining that there on 3C. 3D, rental property. If the property was occupied by a tenant at the time the lender acquired the property and the lease, and the tenant had a bona fide arm's length rental agreement at fair market rate, the tenant may be entitled to the balance of their lease term or at least a 90-day notice for termination of a month-to-month tenancy. In addition, certain rent control jurisdictions have asserted that the tenant has rights under rent control after a foreclosure. Moreover, the tenant may be entitled to return of their security deposits, even if the security deposit was not given to the lender after foreclosure sale or to the buyer of a bank-owned property. So just know that the tenant always, that contract supersedes foreclosure or sale of the property. So the tenant still has rights. Brokers, sales not exempt from the broker's obligation to conduct the AVID. Okay. And agency, it's not exempt from the obligation to provide agency relationship disclosures. So your agency disclosure. By signing below, the undersigned acknowledge that each has read, understand, and received a copy of this REO advisory for the listing. So this is between the seller and the broker. So this would be signed between the bank and the seller at time of the listing agreement is when we would use this REO advisory here. Okay. So this is between the bank and the broker for a listing agreement. There we go. REO advisory there. We have the RGM. This is our radon, gas, and mold notice and release agreement for the U.S. Department of Housing and Urban Development. Now, the only time that we would utilize this is if your buyer is buying a property that has been foreclosed by an FHA loan. I think is the only one that falls underneath this. Okay, purchaser acknowledge. And just so you know, it's always disclosed in the MLS if it's a HUD-owned property. They usually have requirements at the beginning. It can only be owner-occupied offers for like the first 30 to 60 days. Then you can roll into investment property offers after that. And it's always disclosed. Usually the property, you have to submit the actual offer through the HUD website. So it's kind of a cumbersome process. But if that happens, we need to make sure that you provide the radon, gas, and mold notice and release agreement for the U.S. Department of Housing and Urban Development, HUD. Okay, so just be aware of that. There, I was trying to see. Oh, because I'm looking at the second page. So they just said that it was revised. I'm not even sure what was revised here. It probably has something to do with the signature lines. Let's look. Hold on. I have a quick summary. This is the seasonal short-term salesperson. REO advisory. I think we're getting close. HUD, notice to purchasers. Form updated to new language specified by FHA. But they didn't tell us what it was. So there's just some new verbiage in there that's specified by the FHA. So nothing major there, but it is going to need to be included on a bank-owned property. All right, we got that one. All right, moving right along to our RA, which is our realtor's acknowledgement. Now, this might be a good form, just so you know, if you're trying to build your case for your listing agreement or build your case for your BRBC of the value of realtors in the transaction, this might be a good form to investigate and look into. So it just talks about realtor's acknowledgement. Do you know whether each real estate licensee in your transaction is or is not a realtor? And then it talks about the benefits of realtors and why, right? So realtors pledge themselves. Here's where the changes were to a code of ethics and related standards of practice covering duties to clients and customers, duties to the public, and duties to fellow realtors. The code of ethics and standards of practice are available for viewing, and it gives the website there. If someone believes a realtor has violated the code of ethics, they can file a complaint at the realtors local association, or the realtor will be disciplined if it is determined after a hearing that a violation has occurred. Right here, we pride ourselves in offering good service and behaving ethically, as we believe that services, clients, and customers that we believe that serves clients and customers well. However, if you become dissatisfied for any reason, I hope that you contact me immediately so that we can resolve the matter. I also want you to know that if I am a salesperson or broker associate, I perform real estate license activity through a real estate brokerage firm. And if applicable, my broker is listed below. If you need to, you may contact my broker for further resolve any issues, right? So it's just saying, hey, come to me first before you file a complaint. So they've just added that verbiage in there. And then here's where the you would sign here, print name, email, phone. Here's your firm. Here's the local association that you belong to with their phone numbers. And then the party that you are representing would sign down here. Okay. And I would say personally, like, I think this is a great form to utilize. Like I said, if you're trying to build value with regards to a listing agreement in your commission, or the BRBC, the buyer representation and broker compensation, going over the importance of hiring not just a real estate agent, but realtor is super important because it adds value to our buyers and sellers. So this is a great form to utilize as part of that. Okay. Moving right along to our PAC, I'm not going to cover this form in detail right now, but just know that if you have a personal assistant, right? So this would be between an associate licensee and licensed or unlicensed assistant. There is a form in your Car Forms library that talks about that relationship. So you don't have to come up with your own contract. Woohoo! Magic, right? So just know that's in here. You can utilize that. There was a couple minor changes, right? Payment of future compensation, deductions authorized by assistant, right? Assistant understands. So just know there's a few minor changes to that form, but it does exist. If you do have an assistant, it's good to enter into a contractual relationship with any assistant that you might have as part of your real estate business. Okay. Let's get rid of that form. We're just moving right along. I think we only have like 3 forms left, maybe 4. This is the modification of terms. This is the modification of listing, buyer representation, or other agreement between principal and broker, right? So this is the MT. It used to be just modification of terms. Now it's modification of listing, buyer representation, or other agreement between principal and broker. So anytime we're changing an agreement between us, the brokerage, our agent, and our clients, we use this form. Okay. Changes between buyers and sellers, we use the AEA form, or the amendment of the existing agreement. And for clarification on things in contracts, we use the addendum. Here they added here, note if this was, remember last week, if you were on, we talked about, or if you've watched that recording, that the listing agreement is limited to 24 months for residential properties of 1 to 4 units. So this, they've also added a blurb here with regards to the expiration date. If we're going to extend the expiration date of a deal. So if a listing agreement is an exclusive right to sell, Car Form RLA, that should be the only one that we use, or a seller revised reserved listing for residential property improved with 1 to 4 units, the renewal may not last longer than 12 months. This restriction does not apply if the seller is a corporation, LLC, or partnership. It is unlawful to record or file the listing agreement or memorandum or notice thereof with the county recorder. Okay, so just clarifying, because there was some shenanigans going on with regards to listing agreements, really long-term ones that were getting recorded against properties and then forgotten about until people were trying to sell. So there's just that clarification there on that modification of terms form. The next form is our mortgage assistant relief services short sale negotiation notice. Okay, again, this is going to be between a seller and the brokerage. if they're trying to short sale their property, which means they're trying to sell their property for less than what is due on the property, which means you're going to be negotiating, or somebody's going to be negotiating on behalf of the seller to try to get the lender to accept less than what is owed. We don't see this very often anymore. Back in 2006, 2008, about 95% of properties were probably short sales. They were either short sales or foreclosed. Here it just says, important notice. The changes were number 3. If you reject the offer, you do not have to pay us any agreed upon separate commission for pay us any agreed upon separate compensation for arranging the short sale, right? And so that this is, hey, once the bank gets back to us, if it's not agreeable, like, you don't owe us anything. If you accept the offer, you will have to pay us the following agreed upon separate compensation for our services in arranging the short sale. So there's like compensation for selling the property, and then there's compensation for negotiating the short sale itself. So that would be here, name of company, brokerage. A lot of times people enlist the third party to help negotiate the short sale. It's a very time consuming process. So I might list the property and company A may be negotiating that sale. That would go here. Okay. And that's all the changes on this form here that you'll see. It's always been in existence. We just don't use it very often any longer. So that's that form there. And then we have our mortgage assistant relief services or other mortgage relief notice. This is between the seller and the broker as well. Okay, so at time of listing agreements, this notice is required by the mortgage assistant relief services rule when a listing agent presents the lender's short sale approval letter. Okay, so we provide this at the time that the lender approves that short sale. This is very similar to that last form. There's just something different on this one, and I'm not sure. Oh, insert the same amount as in the Marsden. So you use both this one and the other one. Okay, and same thing, they just updated the verbiage that, hey, you don't have to pay us, and if you reject the offer. So we do it at time of listing with the other form. And then this one is we provide it to them at time that the lender approves the sale with that offer from the lender. We would then provide this form as well, which has the same changes as the last form. So those are how those two forms are utilized, the mortgage assistant relief services offer of mortgage relief notice. Okay, one at time of listing, one at time of letter approving short sale has been received from the short sale lender. I know that's totally confusing. We have our last form here. Here's the delivery of or failure to deliver short sale lender written consent. So this goes between the buyer and the seller. Okay, section 1 is the same, except they broke it out and gave it an A, B, and C. So we have section 1, A, B, C, short sale lender consent to all terms and release of seller. That's where the seller signs there. If cancellation, section 2 allows for cancellation. So if the short sale lender consents, if the seller agrees to all of the terms provided by the lender, then section 1 is signed and dated, and that's the end. And we check that box. If the short sale either fails to approve the short sale, the lender, or the terms aren't acceptable to the seller, then we move on to box number 2. And we check that box, cancellation based on failure to deliver short sale lender consent to all terms within the time specified in the short sale addendum. Only requires signature of party canceling. So this allows either the buyer or the seller to cancel if we don't receive that in the amount of time necessary. Remember, we can always extend that addendum with an extension of time addendum. Okay. A is seller represents that by the date specified in paragraph 1 of the SSA, that's the short sale addendum, all short sale lenders either have not responded or have expressly denied or changed the terms of the seller's request for approval of the agreement. Pursuant, I have the little bug slugging me. Okay, pursuant to paragraph 1D of the SSA, seller cancels the agreement and buyer shall be entitled to the return of the deposit, if any, in accordance with the attached contract cancellation form. We still use the CAR form CC. Okay, so 1 is seller's canceling. We haven't gotten it. They changed the terms. It's failed, right? B is buyer represents that by the date specified in paragraph 1 of that short sale addendum, seller has not delivered to buyer or buyer's agent either a short sale lender consent to the agreement or a short sale lender consent seeking changes to the agreement pursuant to paragraph 1D of the SSA. Buyer cancels the agreement and buyer shall be entitled to a return of the deposit, if any, in accordance with the attached contract cancellation form. So that would be, hey, the date's come and gone now buyer's done waiting and they're going to move on. And then C2C is pursuant to paragraph 1F of the SSA, either seller or buyer cancels the agreement and buyer shall be entitled to a return of their deposit. So that's the third option there for the cancellation. Seller and buyer both are going to sign here on their respected lines there. And then they also have an addendum, amendment, that was good, of the agreement because the short sale lender consent requires changes to the agreement. So, right, so in this form, we either are going to sign under for box number 1, we're either going to sign for box number 2. So we're either, hey, we're still in agreement with the purchase agreement, we got the offer back from the lender, we're good to go, let's sell from the seller, and then the transaction proceeds towards closing. 2 is, hey, we're canceling it because we haven't received or we're not in agreement with what the lender said. And 3 is, hey, the short sale lender agreed to sell, but they want some changes made, and here are the changes, right? So attached to this form is the conditional consent of all existing lenders and lien holders, short sale lenders, to the agreement. The terms of the conditional consent shall be incorporated into the agreement. Time periods in paragraph 2(3) of the SSA, which have not previously begun, shall begin the day after acceptance of this amendment. Expiration, the seller proposes this amendment to the short sale agreement, which may be withdrawn by seller at any time prior to acceptance and shall be deemed revoked unless by 5 p.m. on the 3rd day after it is signed by seller or by blank date and time. This proposed amendment is signed by buyer and a copy of this amendment is delivered to seller. Acceptance, the foregoing terms and conditions amending the short sale agreement are hereby accepted and the undersigned agrees to the above terms and conditions and acknowledges a receipt of a copy of this amendment. Under acceptance, this amendment shall be deemed incorporated into the agreement. Okay, so we're either going to check box 1, 2, or 3. We're either going to sign under 1, 2, or 3. Please don't sign all 3. I feel like this should be a seller signature line here, not a buyer line, but that's all right. Maybe they'll fix that and update it. We'll see. Because it should be, hey, seller's proposing this, and then the buyer gets to either accept it or not accept it. So it seems like there should be a seller signature line there, but we would check this box here. Seller's not going to sign. We're just going to attach the changes to the agreement through the short sale lender's approval letter there. Buyer is either going to sign that they agree to it, or they're going to sign down here that they don't accept the amendment. Okay, at which point we're then going to cancel the contract. Okay, so that is the last form in the updates that I'm going to cover as part of the December 2023 update release. Remember, these are all going to be in your car forms library. They're slated to be there by the 18th of December, so next week. So begin looking for those. Hope you found this useful. Hope you're watching the recordings of this. It's got some really important information. Forms that you may not have been aware even existed are included in some of these updates, which bring awareness to those forms and the opportunity to utilize those. So hopefully this was helpful. I hope everyone has a great day, and we will see you all soon. We'll be back on Thursday.